Hello, everyone, and welcome to Uncivil Law, where we learn from the misfortunes of others. We're going to be talking about the first day of the Kyle Rittenhouse shooting. Swearing and profanity will be involved because it's that kind of day. So, yeah. So, how did the day go? Well, let's just go in the order of sequence of things that happened. A lot of this will be repetitive for people who watched my stream with Nick, but for those of you who didn't, I'll give you my opinions again. So we start with the opening arguments. The prosecution's opening argument was textbook. It was 9 out of 10. There was nothing truly exceptional or nothing truly amazing about it that would pop over to 10 over 10, but it was a fully competent, good opening argument. It had a good narrative. It told the story. It was slightly misordered in parts, or I would have put it in slightly different order, because it jumped around in ways that I found a little bit confusing, but I use that word minor. Like, these are tweaks, right? These are minor tweaks. But on the whole, it's a fully competent opening statement. It tells a story. It tells about the people involved. It tells about the places involved. It tells you who, what, when, where, why, and it drives you through a narrative story that puts it all into a common frame that makes it very easy to understand and very relatable. So let's talk about the defense's argument. Yeah, the defense's opening argument was pretty bullshit. It sucked. It just truly sucked. The defense's argument was kind of incoherent. It lacked any sort of story. It lacked any sort of narrative to bind things together. It lacked any kind of framing. It was jumbled, confused mess that was not well orally presented. It had none of the wonderful features of good speech and good presentation, such as, for example, vocal variety, where you change your pitch, or you change your speed, or when you come to an important point, you stop. None of that. It was just one long recitation, and there were a lot of run-on sentences, and there was no cohesive story. I didn't know what the defense's theory of the case was, except for something, self-defense, something. But there was no story. The defense brought in 43 videos and photos into their opening argument. Stuff we've seen before and stuff that should be interesting. The defense found a way to make it uninteresting. I don't know how that's even possible. How do you make stuff of a shooting that happened on a very turmoil-filled night uninteresting? It was pretty bullshit. It was bad. Now I have to address some of the people in Nick's chat from earlier, who apparently are, at least some of them are of the opinion that narrative and story is complete crap. And why am I even talking about narrative and story? This isn't a Hollywood film. What do you mean narrative? What do you mean story? All that matters are the facts. He presented facts. What are you talking about this presentation stuff for? And I have to say, look, listen, dipshits. I don't know how to explain this to you, but I'm going to try anyway. Human beings thrive on stories. Our societies are built on stories. They are built on narratives. Well before written communication was invented, the only way information was spread was orally, through stories and storytelling. It's kind of important. It's kind of important to the human condition. It is built into us and wired into us to want stories and narratives. So all these people who are like, oh, the narrative doesn't matter, the stories don't matter, what do you think this is, Hollywood? Ha ha ha. It's just facts. I'm like, you don't know what you're talking about, you're out of your goddamn mind. And you can just show that to, I mean, I shouldn't have to convince you of this. Why do you think the mainstream media spends so much time on narrative and framing? Right? We all complain about this when it comes to the left media, about their narrative and their framing, and that we say this is bullshit. Why are they trying to maintain the narrative constantly as they're presenting the story? But they're maintaining the narrative because they understand narrative is important, because human beings like stories. You can't respond to it, but with here's some facts, though. How am I supposed to feel about these facts? You have to tell me why these facts matter. Let me explain this to you. You have to, there is a person dead, okay, or other bad thing that happened in some other case, but let's just stick with this case. There are people who are dead. People dying is bad. I think we can all collectively agree that death is not desirable. None of us particularly want it. But, so, a jury is being asked to figure out why this person is dead. You know, there are basically two meta-narratives. There are two meta-narratives. The prosecution is, this person did the bad thing. They are a bad thing for doing the bad thing. We must force our moral judgment upon them in the form of a legal judgment, but they are the enemy, right? That is basically the prosecution's meta-narrative in basically every case. Some theme, and then you have a more specific story or a more specific narrative that conforms to that meta-narrative. The defense has basically one of two meta-narratives. This isn't the guy, so they're wrong on some sort of element of he's not the guy, or he is the guy, but what he did is what he did was okay. You know, he's not the guy. He didn't do the thing, or he did do the thing, and it's okay. So basically, three narratives. The prosecution's narrative is this is the guy. He did the thing is bad. Bring him to judgment. There's basically one narrative. The defense has three options. Or I guess, he isn't the guy, he didn't do the thing, or he is the guy and he is the guy, he did the thing, but somehow it's okay. Right? And then you need to have a narrative that explains why it's okay. You need to be able to tell this jury why it's okay. And that's obviously the situation we're in. We all know there's no dispute that Rittenhouse shot the people. So why is that okay? That's the narrative you have to tell. And what you want to do ideally in a case is you start the story right away. You can do the entire story, at least the entire framing of the story. So you don't do the entire story full stop, but you do what you might call like a comprehensive outline. That's sort of the opening statement. Here's a comprehensive outline. Here is what you will hear. And you either explicitly or more often implicitly do it in such a way and in such an order that it tells a story through a narrative arc, that things follow in a story with like people and places and things that tell a story in an ideal way. Then what you want to do is when you're considering what your witnesses to call, when you're considering witnesses to call and in what order, you have to consider, because it's possible that the same piece of testimony could come from more than one witness. So more than one person could possibly testify about something you need to be said. So you might say, okay, which of the people should testify about it? Do they all testify about it, or does one? And usually what you do then is you figure out the order that needs to, the order of the witnesses that conforms to the story. The only sort of exception to that is if the defendant himself is going to enter the picture, because then you have to consider that as a separate factor in terms of like trial strategy, whether you want to put him first or last, because there's some strategy elements there. But otherwise, you want to put all the witnesses in an order to tell the facts that they observed in an order. This is all preferable and ideal, in an order that conforms to the story. That's the ideal. And then at the end, here's the evidence you want to hear. You tell the story again with the specific pieces of evidence you hear and other sort of notes that conform to that, right? It's all story throughout. The entire idea, because the jury gets to write their last chapter of the story. That's the thing. The jury gets to write the last chapter of the story. So what you want to do as an advocate is you want to, from opening to what witnesses you call, in what order, and what do they testify to your closing, you want to tell a story that the only possible conclusion to which, the only way the story can end is for you to win. That's the ideal. You want the story to be constructed in such a way that there's only one possible way the last chapter can be written, which is that you win. And then the jury writes the last chapter for you and you win. That's the idea. This idea that some of the people in chat had, that you don't need story and you don't need narrative, you don't need framing, is such unbelievable bullshit. I don't even know where to start. It's like, there is a performance aspect to law, particularly at trial, because you're talking to a jury. They're your audience. They're your audience. You have to, you're putting on a bit of a performance. And you have to make the audience engaged and entertained along the way, so they will follow your story. Right? It just flows from beginning to end, and then you get back off like, that was just a great story. So you can do this and tell the story, and it's like, oh, I'm just gonna dump the videos at people. Look how good the videos are. The videos speak for themselves. I'm like, I'm like, I maybe I'm wrong about all this. Maybe some people don't care about the story and don't care about narrative, but I think they're a bunch of liars, and they don't basically understand how important narrative is and how important story is. What is a better history teacher? Is a better history teacher someone who just teaches you a lot of dates about when things happened? Is that more interesting than a history teacher who tells you about the dates in the context of a story that makes you engaged to care? You know, I'm sure you've had teachers in your life at some point who have just not been very good teachers. One of the reasons they might not be a good teacher is because they suck at storytelling. And storytelling, it to the extent it can be used, it should be used everywhere. Maybe it's a little bit harder in some subjects than others, but where it can be used, it should be used, because humans thrive on stories. We thrive on narrative. There's a reason we go to the movies. There's a reason we read books. I don't know why this is such a controversial view, but apparently some people in Nick's chat are of the opinion that none of that matters when you get to trial, which just blows my fucking mind. So I don't know where to start with these people. I think the facts just matter. I think the facts are important. I thought the thing was good. It just laid out the facts. I was convinced. Are you sure? Are you sure that you're not perhaps unduly Team Rittenhouse? I'm Team Rittenhouse, but at least I can detach myself from my own views, what I want to be true, to what's happening in the courtroom, because the jury is the audience, not me. You don't have to convince me. I'm already on Team Rittenhouse. So the question for me is not, what do I think, but what will the jury think? And I'm like, well, here's what they're faced with, and this blows chunks. And I have a feeling that a lot of the people who are opposing me in Nick's chat are so Team Rittenhouse, they can't even begin to conjure the concept that some people haven't made up their mind, let alone decided the case for him. It's like, I don't know what the problem was, but there's some smooth brains in the chat. It was very, very annoying. Very annoying, because I'm like, I don't know why I should have to fucking explain to you people. There's a reason we go to the movies. There's a reason we read books. There's a reason we watch shows like Breaking Bad or The Wire or insert your other of choice. There's a reason we do that. We thrive on stories. We thrive on narrative. If your lawyer can't tell a story, you're going to have a bad time. Now, it is perfectly possible. It's perfectly possible that he might win anyway, because the evidence is just so overwhelming that, that the jury, even though the narrative sucks ass, Maybe it's true that the evidence is just so overwhelming that even though the narrative sucks ass, they will be able to look at the evidence and be like, yeah, not guilty anyway. Maybe that's true. But do you want a lawyer whose narrative sucks ass, who can tell the narrative, who can present the facts, or do you want a lawyer who can provide the story? So you just make it even easier. It's like maybe the facts standing by themselves are enough. Wouldn't you like a lawyer who can make it even easier for the jury by providing a cohesive, coherent narrative and story and architecture to the case from beginning to end? So when you get back into the jury room, you say to yourself, geez, there's only one conclusion to this story, you know? And then, yeah. And then anyone arguing for any other position doesn't make sense because that can't be the way the story ends. Yeah, it's just like, I don't know why this is so hard, but I'm apparently haven't explained this to some idiots. So that was fun. Ryan Carr says, you're implying the jury can come in and bias. Do you think that's a fair starting point? Well, for better or worse, well, let me put it a couple ways. I think there might be some unbiased jurors, although in Kenosha itself, it's a little bit harder, obviously, because they're more in the middle of it. But more to the point, at least as a conceptual framework, and God knows the ability of the jury to do this. This is a point of voir dire to be able to do this. But the whole point, or one of the ideas is we're going to select a jury that can put aside everything they know other than what they learn in this courtroom, right? You know, you've now entered the bubble. You know nothing except what will be offered inside this court. That's the premise, right? So are there some people who haven't made up their mind? Probably, hopefully. Are there people that maybe can put aside their own conclusion, like me? I'd like to think I'm such a person. Maybe it's too self-flattering, but I'd like to think I'm capable of it. Is there someone who's like myself who can put aside my own belief and just limit myself to what's in the courtroom, which is kind of like what I was trying to do earlier today. And I'm like, I'm telling you guys, it's not looking that great for Kyle right now because I'm putting myself in this hypothetical mindset where I have to put everything I know aside and just evaluating it based on the evidence. And here's how it's going. Not that great. So is it fair to think some of the jury is, but here's the thing. Here's the thing. Let's assume that that's not true because that's too idealized. Okay, so let's assume that's too idealized, and let's assume the jury is coming in with some preconceptions or even some prejudgments. If that's true, how much more important is it for you to tell a good story? So if your premise is the jury is coming in biased, and your concern obviously would be bias against me. You don't really care about bias for me, except in so much as you want to refortify them. So that would be helpful, but that's not your primary concern. Your primary concern is not the people who are biased in favor of you. It's not necessarily even the people who are neutral. Your primary concern is going to be the people who are biased against you, right? Those are the jurors you don't want. Great. So since they're biased against you, how much more important is it to tell a good story that will show them the error of their ways and will drive them to the inevitable conclusion? How much more important is it? And it may not be possible, right? This is like an idealized version. So you may or may not be able to pull this off depending on how good you are as a lawyer and also depending on how biased the juror that you're trying to convince of. But this is the idea, at least in principle. It's like, I want to tell a story so good. It would be the rough equivalent of going into a movie thinking you're going to hate it and love it. Like, I want to tell a story so good that by the time you're done, you will have forgotten every bias you have, and you'll be like, it must be a verdict for me. So narrative architecture is even more important if you assume bias, it seems to my mind. So that's what I think. I think storytelling and narrative is important no matter how you slice it. And of course, to the extent people are biased in favor of you, you want to keep them that way. So narrative doesn't hurt there either, right? It's like you don't want to bore them. You don't want to bore the people that are biased in favor of you and let the other guy steal by use of their narrative, right? Because you're trying to ideally pull the same trick on the people biased against you as they are for the people who are biased against them, which is the people who are in favor of you. So you don't want the other side being able to do that. So you need to reinforce them. So you don't want their story to be so good and your story to be so weak that you lose your own side. This is not good. And another thing also, of course, the other thing that is worthy of note in this entire discussion is this all, of course, depends on your facts and what's possible. So it's possible that you'll be left with a situation in which no story and no narrative will get you out of the hole. Right? The ideal is to be able, as I said, the ideal is to be able to tell a story that from opening through the questioning to the close, the ideal is to tell that story in such a way that the only conclusion is a verdict for you. That may not be possible, particularly if you're presented with particularly horrible facts. So, but then you still tell the best story you can and you hope for the best. And sometimes hope beyond hope. But what else can you do? It's like all you can do is tell the best story with whatever you have. If you're the defense, you need something other than my guy. You need something other than my guy my guy is the guy, he did it and he's bad, which is the prosecution's case. You need some story other than that. Unless you're just going to try to attack unless you think that their case is so weak that you can attack their case and win it by discrediting their evidence so much that you'll win when they close their case. So the only way the story doesn't matter is if you think their case is so weak that by the time you get to the end of their case, you're going to win as a matter of law. I wouldn't rest on that principle. And even if that is the case, you're still trying to convince the judge. And the judge is a person. So even in the case where you think the prosecution's case is so weak that by the time you get to the end, you're going to get a judgment as a matter of law, you still want to probably tell that to the judge in a way that tells the story so the judge will want to do that. That would be nice. That's my view of it. So, good times. I've been talking about this for a little while now, but I was really pissed off about it. So, yeah, I saw someone in chat says, it's thoroughly tenderized, but I was so pissed about it. I wanted to rant about it a little bit, but we can move on. Anyways, so let's go to the witnesses that we had. So the first witness was the friend who purchased the firearm for Kyle. They shot together in their backyard. They went hunting together, and I don't know if he supplied the firearm the day of is quite the right way. The firearm was already in the open, so it was at his house though. So whatever. So the firearm was picked up from his house and all that stuff. So that was the friend, right? So I thought the prosecution did fine. I thought that their questioning was very good. I thought they asked the right questions from their perspective to try to get to where they're trying to be. I thought their questions were good. I thought they had good control of the witness in terms of the flow. And the witness did give some answers that were not great for the prosecution, but they handled those situations well, which is, well practiced by the prosecution. So I thought his questioning and framing was very consistent with his open, and it was very good. I thought that the defense lawyer, in terms of the cross-examination, was also very good. I still didn't really know what his overall narrative is, but he did get some good points from the friend. He got the reason Kyle was on the ground instead of somewhere else, because he was asked to be there because of his medical skills. He got the reason why Kyle was moving around, because he was asked to. By him or not him, we're not sure, because he seemed inconsistent on that point. But someone was telling him to move from place to place, so that's why he was moving, as opposed to being in a fixed location. And so forth and so on. So there was moments like that where you got some really good material from that witness for the defense. So I thought the defense's cross-examination was, again, solid. It was a little muddled, but cross-examination isn't as structured as direct, because when you're direct examination, you can literally write out every question. and you can just write out every question. And there shouldn't be too many surprises if you've prepped your witness well, which is different than coaching, incidentally. But as a cross-examiner, you can't quite do that, because you can obviously script out some questions, but you don't know what they're going to testify to. So you have to play a little bit on the fly. So you wouldn't expect it to be as tight as a direct. So that's not a slight against the defense lawyer. It's just a nature of the beast. So I thought his cross-examination was fine. It was good. He extracted a lot of good points. There was a nice save there where he was talking about Kyle's reason to bring the gun for himself, where he's like, he brought it to protect himself, and he basically punted on the question. So there was a little string of testimony there that was not particularly great for the defense, and it ended the string of testimony that wasn't great for the defense ended with this line, or ended with this exchange of, was the reason Kyle Rittenhouse brought the firearm for his safety, and he basically deflected the question. So the defense saved it by saying, you brought the firearm for your safety, to which he answered yes. So then you just let the implication sit, which was good tactics. You don't ask the one question too many. If he had asked, so therefore he brought it, he was obviously not going to get a yes answer from them, so he did the next best thing. It's like, it's the reason you did it, right? Yeah. And so you let the jury draw the natural inference. Good job. Good job. I thought the redirect was, I didn't get anything out of it, really. It didn't seem particularly purposeful. So, as to the second witness, for this FBI witness, I don't know 100% what's going on there, because we didn't get to see it. We didn't get to hear it. And I don't believe there's a transcript that's live. So, but there are some quotes out there that are raising some question flags. So this FBI person, it's a little bit unclear. So the FBI had aerial surveillance from a helicopter or a drone. I'm still not sure. I guess a helicopter would be the most logical thing. But they have aerial surveillance from something, and they have FLIR. So they basically have an infrared camera, so they can see infrared movement of the people that happened. Okay, fine. So it was a little bit unclear from the news reports that I was reading. It seems a little bit unclear what this FBI's connection to all this was. Was he the pilot? Was he in the aircraft? Was he piloting the drone? Is he some kind of official records officer and that's his purpose? So his connection to the video seemed a little unclear. Also, the purpose of it seemed unclear, because the only questions that appeared to have been asked by the prosecutor were basically, is this the video you took, in so many words. They didn't ask about any identification. They just, as I understand it, basically they asked some preliminary questions, I'm sure, about his background and training and blah, blah, blah. But basically the only substantive question they really asked, as I understand it, was, is this the video the FBI produced? Something to that effect. Okay, so then the defense wants to cross-examine this, and they ask about the tail number of the plane, which I don't know if that's necessarily relevant or not to get the exact tail number. But if the question is, are you in the plane, or are you in the plane / helicopter / whatever, I'm not sure you necessarily need a tail number, but to know that are you in the aircraft? How many other people were in the aircraft? Maybe they can testify as witnesses to something, or they're potentially disposable. Were you the camera operator on the night in question? Were you viewing this in real time? If so, then maybe you know that this is authentic because you saw it real. Otherwise, how do you know this is authentic? Or what has been changed? Also, apparently, this is a nice little thing. Apparently, there was an HD version of the infrared camera, which the FBI has apparently lost. So that's just great news. That's just great news. Way to go, FBI. Yeah. Yeah, it's just something. So something seems slightly rotten in the state of Denmark, as they say. Something is not quite adding up here, based on what little I know about this witness, because I didn't get to see him, and there's no transcript, so I'm basing off some news articles. But something seems a little rotten. Like maybe he's not as connected. How can he authenticate this tape? What is his basis for authenticating it? And so forth and so on. It's like, I don't know. But the defense did use it in their opening, and I think they stipulated to the frame being authentic, so maybe that authentication is not an issue. But I don't know. There's something a little bit weird here with this FBI official. But until we can review a transcript, it's a little bit hard to comment more intelligently, except to say something looks like it might be up. So we'll see what happens, I suppose, later. Then we had witness number 3, who is an influencer, social media influencer, and works for himself. And for the life of me, I can't figure out why the prosecution's calling him, at least so far. I don't understand what he's doing there from the point of view of how does he help their narrative. What part of the story is he telling? I didn't get it. And why did we show 15 minutes of this guy's video? What was the point of that? From the gas stop. Why are we doing that? Because the video doesn't really show anything. It's a video, the one we saw, of people at this gas station. We see some people armed, some people not. The people who are sort of within the boundary of the gas station in this 15-minute video appear to be acting in a peaceful manner. As far as I can tell, they were standing around and having loud discussions with each other, but I didn't see any obvious signs of violence that was readily apparent to my mind. So, okay, people were standing around in this gas station lot, just kind of debating the issues. Kyle Rittenhouse was there. We saw him on the tape, so okay. But I don't understand what this guy is doing for the prosecution's case. So I can only hope it's going to become clearer tomorrow when he resumes testimony of like, oh, that's why he's being called. Oh, that's why that video was important. It wasn't readily apparent. So hopefully it'll become more apparent tomorrow. So that's basically why. It's basically my analysis of the day. So I suppose on balance, it's hard, I suppose you give it to the defense because they were able to extract some really good things on cross that were really helpful for them. They did a very good job on prepping for the questions they wanted to ask for cross, because it wasn't obvious to me going in what questions would be asked on cross. And I thought that they asked good questions. They got good answers that can really help them later down the line. So I think the day goes overall to the defense, and one can only hope that someone other than this guy closes and is able to put it together in a bow so that the jury will, forget all about the bad opening and just focus on the closing. So, yeah. So that's where we are. Oh, by the way, okay, I wanted to comment on one thing more. Teos is used, said the drone video is so confusing. It seems the prosecutor could use it to spin the narrative. The call ran at some of these people. That seems to be the purpose of the video, to show that Rittenhouse was chasing some of the people. Whether or not he was chasing or not, or merely running in the same direction for completely unrelated purposes. But yeah. So there is one other thing I wanted to point out. Why the prosecution was asking some of the questions they did, or why the prosecution made some of the statements they did in their opening. Because part of the prosecution's opening, a significant part, could be understood as what a defense lawyer would say. So why was he doing that? And some of the questions he even asked on direct could be thought of as questions the defense lawyer might ask, because some of the answers. So why was he doing that? So this is my view of why he was doing that. So basically, here's basically what the prosecutor said during opening and basically got from the questioning that was sort of maybe makes you wonder, why was he doing it? So the prosecutor said / got that there was a lot of violence going on that night, that there was rioting. He used the word rioting. I think he used the word arson and people and violence and things like that. And he was saying basically that the situation that night was overall chaotic and, unsettled. Now, you would think, okay, why is he doing that? Because that's all good for Rittenhouse, isn't it? Because that goes to his mental state of why he perceived, at least goes in part to his mental state of why he perceived the threat he did. So why is the prosecutor doing this? And it seemed to me, and this was particularly clear when the prosecution was examining the friend. He asked the friend about rocks being thrown at him. He asked the friend about tear gas canisters or whatever it was, that things were being thrown at him that were potentially dangerous. And he pointed out the obvious. You didn't feel like you were in threat, right? So you didn't you didn't use your gun because you didn't feel like there's a threat. So it seems like the reason the prosecution is painting this picture of the danger that night, the overall danger, is because he wants to say that the situation was dangerous and lots of people had guns that night. No one else fired their gun, or apologize, someone else did fire their gun. Let's try again. No one else shot anybody. I believe that's true. No one else killed anybody for sure. So, and I don't believe there's been any suggestion, at least, that anyone else was acting in self-defense that night. So the idea appears to be that everyone else, although they were involved in not the exact, but roughly the same situation, because they're all in the same town on the same night. So their situations are very similar in a lot of ways. Since no one else felt the need to use their firearm in self-defense, despite all these chaos, despite things being thrown at them, despite all that stuff, since no one else drew that conclusion, it was unreasonable for Rittenhouse to draw that conclusion. He was part of the same soup, the same milieu that everyone else was in. So since everyone else apparently didn't draw the conclusion that they need to use their firearms in self-defense, then and they were in roughly the same situation, then therefore Rittenhouse also was unreasonable. That seems to be the direction the prosecution is going. The counter to that argument is also fairly obvious. In general, the situation is the same. But where it matters is in the specifics. That's where the specifics with respect to Rittenhouse are different with respect to the situation for literally anyone else, right? At a 30,000 foot view or a 10,000 foot view or 1,000 foot view, they look the same. But when you get down closer to the details, there are details that change the analysis. So the counter for the defense is fairly simple, all things considered. Well, the idea at least is simple. The execution might be more difficult. But the idea is at least the circumstances in Kyle's specific case warranted this action. So whether or not anyone else's situation warranted the action or not, this one did. So take it from the general to specific. It's basically the forest versus the trees. Yeah, and which one you should be looking at depends on the situation. So the prosecution appears to be saying, look at the forest. The forest is very dangerous. No one else in the forest thought there was a danger, so the forest is okay. And the defense is saying, look at the tree. The tree is sickly, and so forth and so on, in this increasingly bizarre analogy. That seems to be where the prosecution's going. That can work. But of course, it requires the prosecution to argue the underlying premise of the situation is chaotic, dangerous, violent, volatile, which gives the defense so much foundation to that for free. So it's a dangerous line of argument. It may be the case that the prosecution didn't have anything better, which might be very well true. But so I'm not saying it was a bad. It's a workable strategy. It might even be the best strategy for the situation. Again, going back to my earlier rant about storytelling, right? I said you want the best story you can, and ideally you want from beginning to middle to end to tell a story that leads to only one conclusion. Maybe the prosecution can't do that because the facts don't allow for that. So the prosecution is doing the best with what he has. He's telling the best story that he can, given the predicate facts he has to put into the story. So he's telling the best story he can. Whether or not he can get to the end is very, very debatable. And he has to concede so much ground to the defense to even make the story work. But it might be the best possible story for the prosecution. So I don't think he was making a mistake, and it's not obvious there's anything better. So I thought the prosecution's doing a fine job as a lawyer, as far as I'm concerned. I think on a personal level that they should have never brought this case, and it's kind of bullshit. But if you're determined to bring this case, this would be probably the best way to do it. So, yay, all that good stuff. So let me take some questions now that I've been ranting at the camera for about 40 minutes and sharing my overall thoughts. 20 of which was me mostly ranting about the importance of story, because smooth brains don't understand story or something. So let me check the bot for questions, and then I'll check if there's anything else. Joe's Med said, a bit off topic, but CNN just called the Virginia governor's race for Youngkin. Thoughts on your former home state's politics? Great win for the Republicans. The Virginia has been tending more blue, but they still are mostly a purple state, so the idea a Republican could win is not shocking. The Democrats in the state legislature hold an extremely narrow margin. I think they held it by like one vote or something. So and they've had Republican governors in the relatively recent past. But this is a state that Biden won by, 10 points? And it appears that the Virginia governor just lost by about 3. So that's a lot. That's a lot of shift. So it goes to show Biden's coattails are kind of non-existent, which isn't really a surprise. And I think it also shows that people are beginning to get really tired of some of this Democratic shit, because they are really tired of some of these lockdowns, really tired of some of this woke politics. I think that the Loudoun County School Board stuff may represent a growing sentiment that is been reflected in this vote. So I'm very pleased. It does seem to be. Now, I think the Democrats, here's what I think. I think the Democrats are just going to absolutely double down. They're just going to steer the ship completely straight. It would amaze me if there's any change. I think they're going to continue posting the most wokest shit they can dream up of, and then they're somehow going to be surprised when they get crushed in the midterms. That's what I think. But it's a very good, promising sign for the midterms that the Republicans did so well. They did pretty well. It's a good sign. Teos is used since most feel this was a textbook case of self-defense, would a quick opening argument of a paragraph or so be good opening move? Say unequivocally it was textbook self-defense. I don't think you want an opening that short for the reasons we talked about story. I think the shortest you want your opening is probably, well, I can't say that because there might, in a case like this, I could imagine you doing a 15-minute open. It would be tight, but I think it might be doable. So I don't know that you want to go much shorter than 15 minutes. He went for 34, and it didn't feel like 34. It could have been a little bit shorter. So there could have been a little fat trim to get it to 30, and it would have been a little bit better for it. But I think given this, maybe you could do it in 10, but I don't think you could do it in much shorter than that. You need to lay out the story in a way that makes sense. So I don't know that you want to go for much shorter than that. Joseph says, working overtime? Yeah, a little bit. Joseph says, I don't think they're liars. I just think they're not introspective about how they think. Could well be. Ryan Carr says, you're implying the jury can come in unbiased. Do you think that's a fair starting point? We answered that already. Assuming that they are biased, it's all the more important for you to tell a good story so you can sway them to your side. Ryan Carr said, very fair points. Appreciate the response. No problem. Harem says, you are a beast. Thank you. Ryan Carr said, did Kyle's friend throw him under the bus? I didn't get the sense that he threw him under the bus. It didn't seem readily obvious. To me, at least, he seemed like a credible witness who was telling a truthful story, which, of course, you're obligated to do, friend or not. So I don't really know that there was anything that was it wasn't readily obvious to me that he was throwing him under the bus. It seemed to me that the story he was telling made sense, given what I know, and didn't seem to be dressed up in a way that was overly prejudicial. And he also said some things during direct that were kind of helpful for Kyle. So I found him overall to be credible. I mean, he's obligated to tell the truth, friend or not, so, yeah. Teos is used. Many police forces use small planes because they can turn the engine off and glide and be overall more unnoticeable. Not that it matters that night, but I think it's more. Could be. Teos' views says, the drone video is so confusing. It seems the prosecutor could use it to spin the narrative that Kyle ran at some of these people. Yes, we see Rosenbaum running in a direction, and behind him, we see Kyle running in the same direction. So Rosenbaum is running a direction, Kyle's behind him running the same direction. So a conclusion you could draw is that Kyle is chasing him. I don't think I have to ask you to imagine very hard any number of other possible conclusions. But the prosecution's going to pick the one that's most damning for Kyle. So he's chasing him. So sure. Internet commentator said, did I call it? They want to paint a picture of danger that Kyle crossed state boundaries to get involved. A dumb kid who entered the situation made it work, escalating and firing. Something like that. Internet commentator says, is he being charged with a hate crime? No. I think the framing of his behavior leading up to it and his character will be crucial. He's not being charged with a hate crime. No. So let me look in chat and see if there's anything else. By the way, if you want to tag me for a question, you just need to start your chat with the word question. Just literally start it with the word question, or start your chat with the @Uncivil Law, and it will pop up in the bot so I can see it. But I'm going to go through the chat for a little while and see if I can find anything that you guys were saying that I want to call or discuss. Michael Onus pointed out, you have to get bad facts on your terms instead of giving the defense the zings. This is also true. This is very, very true. It's called drawing the sting, usually, by lawyers. If you have bad facts, and the fact that the town is chaotic is not helpful for the prosecution, you do want to mention it first some way. So you have to kind of acknowledge that, and then you have to figure out what to do with it. And I thought the way he did it was as well as probably could be expected. But you're absolutely correct. If you have bad facts, you want to get out in front of them. Omega Point Research said, whose criminal records can be used as evidence? To my understanding at this point, no one's criminal records can be used as evidence. The reason would be just because they were a criminal in the past, well, there's two reasons. Just because they're a criminal in the past doesn't mean they're a criminal now. And also, Kyle Rittenhouse can only rely on what he knew. So presumably he didn't know any of those records, so it would be necessarily irrelevant to his decision-making. what they did or did not do would be relevant. So their actions and behaviors are relevant. And whether they're ex-criminals or not doesn't really change the nature of that. So it's strictly speaking irrelevant. Also, it's just a straight up character attack, and that's not typically allowed unless someone else opens the door, which the prosecution might have done at one point in the opening by calling someone a good person, but the defense, the judge might let that small one slide. It might not be enough to open the door, but it might be. But yeah. Someone was very rude to me in chat, and we do have a standard rule of, not be a jerk. So I don't know if that person got timed out or not. Let's see if my mods did their job. Yes, they did. Fantastic. Good job, Hedinger. Teos, as you said, more of a comment, but with the revelation of the FBI video gone missing, I think getting the entire law crew together for a roundtable on the case might be nice. Fair. We'll try to do that. Joseph said, pound the facts, pound the law, pound the table. Is that what we're seeing here? Love what you do, bro. Something like that. Cody Sam says, trials like these can often take a long time. Are you taking the over-under? This takes 6 months. They've said 2 weeks. They've already said 2 weeks, which seems like an obtainable goal, given the witnesses they're expecting to be called. So 2 weeks sounds, yeah. So I'd go under, I guess, way under 6 months. I think they'll be done probably within 2 weeks. Sounds right, given the number of people who have to be called. Internet commentator. So who else? This case has everyone divided. I barely know anyone else who's willing to withhold judgment till seeing the whole trial. I do my best to put myself in the position of a juror who is supposed to be ignoring everything but what I hear. So that's the frame I'm trying to put myself in. So hopefully that's working. Anyone else? Internet commentator, message me on Discord and we'll talk. A question, at what point would the FBI... You put a colon there, so it didn't catch the bot, but I saw it. Yeah, you have to literally just put the word question without anything else, but yeah, I saw it. Question, at what point would the FBI video need to have been made available to the defense? I think it has to be, I mean, it seems like it would have to be made available to the defense as soon as it's made available to the prosecution, which doesn't seem like what it happened, because it's Brady material. It's material that could be used to argue that he's innocent, right? Rather than chasing him, it was Rosenbaum getting in position for an ambush. So it seems like Brady material. So if it's Brady material, it has to be disclosed basically as soon as the prosecution got it, which doesn't seem like it happened. It seems like the defense got it only 5 days ago. Did I understand this correctly? And the prosecution got it way before then. And also they got it from the FBI rather than the prosecution, which also seems really weird. Also, I'm not quite sure what the FBI's hang up on this video is. Like, why they're being so cloak and daggery about it. That seems also odd. I don't quite get the FBI's concerns here, but yeah. So if you go down to said protest, everyone knows what you're there for. I don't understand what that means. If you go down to a protest, you're there to protest. That would be the purpose of you being there, hopefully. Yeah, Angela Nicole says exactly right. Yeah, there were a lot of elements in there that seemed like they were defense arguments. And so I'm like, okay, well, we're going to assume the prosecutor's not an idiot, which didn't seem to be called for based on the overall construction, seemed well planned. So why is he doing it? Well, here's why he's probably doing it, because of what I said. It's like, yeah, but if you didn't get that, then hopefully when I explained why he was doing it, he's doing it with a reason in mind. And so it makes sense. And it might be the best that he's got. You're taking a mental health break from Discord? I understood. What would I do? In what situation? Superior said uncivil law. One of the men... Oh, it did capture the colon. I misspoke. It just took a while for some second. One of the men that ran up to Kyle immediately backed off and wasn't shot. Could that be used as defense in some way? Demonstrating restraint. Sure. Absolutely. Yeah, absolutely. That he didn't shoot someone when they're no longer a threat. Absolutely, it could be used in Kyle's defense. That will come up in the defense's case in chief. I wouldn't expect it to come up in cross-examination, although it's possible. But it's much more likely to come out of the mouth of a defense witness. Cody Sam says, could there be... An internet commentator responded to me privately. I get that. Cody Sam says, could there be weird over the video thing because they plan to use it to convict other people? I don't quite get all the cloak and dagger. The only reason the FBI person should be anonymous. Well, he's not anonymous. We know his name, and he will be in the transcript, and people who are in the gallery could see and hear him. So it's public for the purposes of what a public trial is. But the only reason to cut him off camera is because he's an undercover agent or some sensitive position, which doesn't seem to be true. So it's a little unclear why all the cloak and dagger, a little unclear what the FBI's concern is here. I'm not quite getting it. The government gets weird about revealing capability. Well, it's a FLIR video. I mean, it's a forward-looking infrared. Forward-looking infrared is not exactly new technology. It's on a lot of police helicopters. So I'm not sure. Revealing that you have a forward-looking infrared camera is really massively surprising. But okay. Joseph said, "In my state, it's unlatched. Bring a firearm to a nuisance. Do you happen to know if that's true? It's unlawful. You mean it's unlawful to bring a firearm to a nuisance? Do you happen to know if that's true in Wisconsin? It is not true in Wisconsin. The mere fact that he had a firearm there was not illegal." And our commentator says, how relevant is unclean hands, since it could be used to argue that we did come there from out of state to join in and therefore contributed to this. The fact that he's there from out of state should be irrelevant. And also, as the defense pointed out quite well in their opening for what value it did have, that he works there. His mother, or was it his father? One of them lives there. So he's not exactly a stranger to this town. But even if he was, he has every right to come from anywhere to be part of that protest. So, I mean, so what if he's from out of state / out of country? What does it matter? If he wants to come for the protest, then knock yourself out, kid, as they say. That should be fine. So I'm not seeing unclean hands from the idea of going to a protest. If it's lawful for him to open carry, which, okay, then that's lawful. So I don't see unclean hands. Yeah. Tails is used, considering the dangerousness of the prosecution throughout this case. Do you think you might get a scolding from the bench when this case wraps up? Oh, disingenuousness. No. The prosecution is within their ethical bounds. They're within their ethical bounds. There was the statement of this being a straw purchase, which could be understood to be a lie depending on how you understood that statement. But except for that one thing in opening, I don't think I saw the prosecution ever tell a lie. They are A lawyer is free to argue any reasonable interpretation of the evidence. You can't argue fanciful interpretations. You can't argue insane interpretations. But a lawyer is able to argue any reasonable interpretation of the evidence. That's one of the reasons, that's one of the lawyers do. They take the evidence and figure out how to present it in the best light possible. So he's within his ethical bounds. I didn't see the prosecutor do anything that, to my mind, was not a reasonable interpretation of the facts. There are many other reasonable interpretations of the facts. Just because there's one reasonable interpretation doesn't mean that there's not multiple reasonable interpretations. There are multiple reasonable interpretations, which the defense will, of course, bring up. And then the point of the exercise is which interpretation makes more sense, which is the jury's role. But I didn't find him disingenuous. Internet commentator says, I was unaware of the fact of one parent being there. Well, he did come armed, though, so it could be said he came looking for trouble or he came prepared. True that. That would be another way to characterize what he did. He came looking for trouble. He came to be prepared. Yeah, those would be fair characterizations. Sliding Edge says, at what point do people who participate in a protest turn riot and with looting and arson, become immune to the consequences of their actions? Does the prosecution ignore actions of those shot? Apparently. I mean, the practical answer to your question is prosecutorial discretion. There were many crimes committed that night, I'm quite sure. Not the least of which is the arson. Burning a dumpster is arson. So there are many crimes committed that night, but the prosecution has prosecutorial discretion. So they apparently don't care about the most of those. So, BG says, would the claim of being unarmed while holding to be a chain be a lie? Depends what you mean by holding. And depends what we mean a little bit by chain. What do we mean by chain? Do we mean like really thick chain, or do we mean what exactly do we mean there? Tony D says, is it possible that Mark Richard Stiles deliberately, matter of fact, to make the opposition seem slick and less credible? I would have to say respectfully, that is a generous interpretation in my view of what's going on. If that style was done deliberately with some sort of, plan in mind to do, if what he did was exactly what he planned to do, along with the consult of other lawyers, and they thought that was somehow a good plan, I didn't see it, but maybe it makes sense to somebody. Joseph said, can't an illegal immigrant do what Kyle did? Yes. Prove he's generally not guilty. Bill of Rights apply. I don't think an illegal immigrant can possess a firearm, if memory serves correctly. Bill of Rights apply once in soil, so there's that. Poking at the woke. Yeah, I don't think an illegal immigrant can possess a firearm, if memory serves correctly. You can't pick a fight and claim self-defense. This is true. This is absolutely true, yeah. So if you can show that Rittenhouse, in a legal sense, provoked the action, then he would lose his self-defense claim. So his mere being there can't be provocation. His mere being armed there can't be provocation. His mere loud words can't be provocation, because those are all legal. Right? You can't provoke somebody through, well, I don't know if it's impossible to provoke someone through legal means. It might be possible, but it doesn't seem viable here. So I don't think his mere being there, I don't think his mere being armed, I don't think the mere fact he might have engaged in some dialogue would be sufficient to constitute legal provocation. But if you can show Kyle Rittenhouse committed a legal provocation, then the self-defense claim is out the window and guilty. So that would be outstanding if the further prosecution, if they're able to do that. We haven't seen it yet. Yeah, there's some specific subsections that deal with provocation. It has legal definitions. Even if he's found not guilty, will he be able to possess any firearms? Yes. If he's found not guilty of any charges, there's no disqualification under any law that I'm aware of. So, sure, he wouldn't be convicted. The federal firearms ban 922G only applies to people who are convicted of a crime that carries more than 1 year sentence. So if he's not convicted, then 922G doesn't apply. So no problem. Wouldn't the fact that he's remaining after curfew play a role? They are charging him with that too. But so is everyone else. I don't think... Yeah, the problem with that is literally everyone else is in the same posture, and I don't think you can really harp that too hard. Sliding Edge, is the state in which riots occurred a stand your ground state? Yes, it is. Although he did attempt to flee, so there's that as well. But yes, it is a stand your ground state. Teos is used. Sorry, this is a bit in the weeds, but if an illegal immigrant can't carry a gun, I assume that's any non-citizen. Well, I don't think that's true for green card holders, and no, it's not true for any non-citizen. Is not true for lawful immigrants, even if by lawful immigrant we mean people visiting here on vacation. It is lawful for a person visiting on vacation to go to a shooting range, rent a gun, and shoot it. So it doesn't apply to any legal immigrant, regardless of what we mean by legal immigrant. After all, a person who's here on a visit is legally immigrating. It's just very temporary. Internet commentator says, if I recall correctly, wasn't it illegal for him to carry a gun into Wisconsin? Yeah, this is a bit of debate between the prosecution and the defense. They're charging him with illegal possession. The way I've read the statute doesn't allow for him to be prosecuted for this. The judge has so far disagreed with this. He apparently is keeping an open mind on it. But the way I read the law, he isn't guilty of possession. But at the moment, he's still being charged with it, so... And also, even if the possession is illegal, that doesn't qualify as provocation, because provocation is external, right? Because the person you would be provoking can't know whether the gun is legally possessed or not. How would they know that, right? How would they know the gun's legally possessed? People are allowed to legally possess. How would you know this is an illegally possessed gun? Unless he just goes around shouting it or something, which would change the analysis. But short of that, so yeah, that would be illegal for him to possess, but it wouldn't constitute a provocation, because how, from the other person's point of view, would it provoke them for it to be an illegal firearm as opposed to a legal firearm? Because how would they know the difference? Is the guy who got his arm blown to bits for being prosecuted for unlawful possession of firearm? Not to the best of my knowledge, but the feds could bring that charge at a later time. They have 5 years to bring the case. So they may just be waiting for this case to be over, especially because he might, if he's going to testify and incriminate himself. So I don't know that is for sure what's going on, but that might be a thing that's going on. Today they said it was not legal for him to own it because it's 17, so how can he legally carry it? The answer there is that ownership is different from possession. Your ability to own something and your ability to possess something are not the same thing. I'll give you a very easy example. A toddler might possess a toy. The toddler can't, a mom buys a toy for a toddler. The toddler is possessing the toy. Does the toddler own the toy? No. The mother owns the toy. So, because they can take it away and they can sell it and all kinds of things, right? So ownership is very different from possession. So saying you have the ability to own a gun and saying you have the right to possess it are two entirely different things. Pokerman said, if I heard 8 gunshots and see a kid running with a gun, I think it's fair to assume he's shooting people. I think it's fair. Yes, we discussed this on Nick's stream. But was the handgun guy ever convicted of a felony? That was my understanding, but or had a domestic restraining order or something. But my understanding was he was. And also, incidentally, it's not a felony. It's any crime that has a sentence of more than a year. So if it's a misdemeanor that has a sentence of more than a year, it qualifies anyway. But my understanding was yes. Where was I? I lost my train of thought. Oh, yes, with Poker Man. Yeah, we discussed this. So for the other people other than Rosenbaum that acted and were shot, it is quite possible and even probable that they have or had a valid self-defense claim. So if either of the people that Rittenhouse shot in that second instance, so as he's running down the street, not Rosenbaum, but the other two people, if either of those people had killed Rittenhouse, I think they would have a viable self-defense claim for the reasons that you alluded to. It would be reasonable for them to infer he is a danger. It's reasonable for them to see he's currently armed, and if they believe at that moment, which is a reasonable thing for them to believe, if they believe he's a shooter / active shooter, and they want to chase him down and stop him, which would be a lawful thing to do, and then they want to try and disarm him, which would be lawful if Rittenhouse is in the wrong, but we're talking about from their point of view and all that stuff. If they use lethal force, then I think they're probably in the clear. So I don't know that for sure, obviously, but my assumption, based on what we know, I don't think Rosenbaum has a claim of self-defense. I don't think that makes any sense. But the other two people who were shot in the second incident, they have a viable claim of self-defense. The fact that's true doesn't negate Rittenhouse's claim of self-defense. This is one of the things you try to do as a lawyer is jump frames of reference. So you try to jump your frame of reference from what does it look from this guy's point of view or this kind of view, or what does it look like from the prosecutor's point of view? What does it look like from the defense point of view? What does it look from the judge's point of view? What does it look like from a juror's point of view? You try to jump these perspectives to try to see how every person would see it. So yeah, they probably, best of my knowledge or best of my belief, they would have a viable self-defense claim if they had killed Rittenhouse, and Rittenhouse still has a viable self-defense claim about them. So this all, of course, is assuming things, but it's reasonable assumptions. It's reasonable for them to believe that he's a shooter. It's reasonable for them to believe he's still a threat. It's reasonable for him, in the name of defense of others, to track him down and stop him. It's reasonable for them to try to stop him. It's reasonable for them, once confronting him, to use deadly force. So, yeah, all those things can be true. It just doesn't change it from Rittenhouse's point of view. Now, I also want to point this out because this is another thing I've mentioned a couple times. If the guy with the handgun is illegally possessing that handgun, which seems to be true, that fact does not negate a self-defense claim. It doesn't help with the illegal possession claim. So just because you're in illegal possession of a firearm doesn't impact self-defense. You can have a valid self-defense claim with an illegally possessed firearm. I've seen it happen in felon in possession cases. It's happened in cases where a person who's a felon is defending themselves, and it's a valid self-defense. It's a valid self-defense. And the method of self-defense they used was a firearm. So not guilty on the murder, but you're still in possession of the firearm, so guilty of that. So whether or not the guy with the handgun is in illegal possession of a firearm does not impact the self-defense analysis for him. So there you go. Joseph said, would you advise the guy with his arm blown off to testify? I think not. Yeah. Do you expect the prosecution to call him? Yes. He's definitely a witness. Yes. And I would not advise him to testify unless he can get some sort of deal with the feds on the gun possession charge, because there's some federal liability there. That would be my advice. Matthew Zisso said, but also apparently Rittenhouse's friend testified without any preconditions in writing, which sounds insane to me. So, okay. Matthew Zizzo wasn't the guy shot in the arm felon, and wasn't he supposed to have the gun? That seems to be my understanding. And now he's possibly being charged with that. That's possible. Yeah, he could be charged with felon in possession. It would be a violation of 18 U.S.C. 922G. It just doesn't impact the self-defense analysis. So, he said, and he possesses a license to carry. Well, whether or not he has a license to carry from the state, strictly speaking, doesn't impact the federal analysis. And I've known of cases in the past. I don't know if this is still going on anywhere, but I know of cases in the past where a state issues a carry permit to someone who's federally disqualified. So strictly speaking, the fact that he has a right to carry card does not, strictly speaking, preclude him from being a prohibited person under 18 U.S.C. 922G. The state can issue these permits to anyone they like. That doesn't impact, for the same reason a state can issue a medical marijuana card. It just doesn't impact the federal analysis. Okay. It's legal for you to carry under state law. It's legal for you to smoke under state law. Great. Let's talk about the federal law now. So, yeah, yeah. So, Gage has no felony convictions. Does he have, what is Gage's convictions? Let's look this up, because I want to get this right as long as we're here. Let's see if we can, all were pled up or pled down? Oh, okay, fair enough. Maybe that's the case. Let's take a quick look at this. Let's see. Okay. Okay, so he's found guilty of a misdemeanor of use of a dangerous weapon. I'm not a felon. Okay, well, that's not strictly speaking the legal standard, although some people do. So let's look up the law and see if it's disqualifying. Hold on, talk amongst yourselves. Okay, so he's guilty of a Class A misdemeanor. Endangering safety by use of dangerous weapons. Whoever does the following is guilty of a Class A misdemeanor. Operates or goes armed with a firearm while he or she is under the influence of an intoxicant. So you're there. It's a Class A misdemeanor. And then do we have a penalty for a Class A misdemeanor? Not in this section, so I have to look this up. Keep talking amongst yourselves. Okay. Okay, here we go. Right. Misdemeanors are classified Class A, Class B, Class C. For a Class A misdemeanor, a fine not to exceed $10,000 or imprisonment not to exceed 9 months. So he is not disqualified if that is his only conviction, because it is not a crime which faces a possible penalty of more than a year. It faces a possible penalty of 9 months. So that would not disqualify him. So he seems to be in the clear as far as I can tell. So fine. It's just, yeah. Okay, so never mind. He's not in, he seems to be clear on the feds. So, all right. Testify away. Yeah. Pleading down can still be an issue if you plead no contest to a serious crime. This is true 420 atheism. The issue isn't the sentence you did receive. The issue is the sentence you could receive. So if it's punishable by more than a year, even if you got no time at all, that would be disqualifying. So, yeah. Angel Angela. Nicole says, someone sets a fire, which in this case is a deadly weapon, while being pushed towards a gas station. That doesn't seem to be true based on the information we currently have that was pushed towards a gas station, but the evidence will continue to flow. And someone being killed is a direct crime of that being committed. It's not clear that there's a direct enough connection for a felony murder issue, but I like where you're trying to go. Internet Comments here says, yeah. As to Baldwin, will he get a movie shooting series out of all the people who get charged? Yeah. Michael Onis says he was given a no carry condition for the misdemeanor, but that may have been temporary. Apparently, since he got a license from the state. Yeah, Derek Chauvin was in no way as divisive as this. I'm not sure that's 100% true. But I think it was more divisive, in my view, but you can have your own opinion about that. Joseph gave me $4.99 and said, I'm found guilty of inspiring thoughts, 2 demerits. Very nice. But pleading to a lesser offense means it's the lesser offense that determines if you're disqualified. This is true. You are correct, sir. If you plead guilty to a lesser offense, that is the offense of which you are convicted of. You are correct, sir. You have been charged with a higher offense, but the only offense you've been convicted of is the lesser offense that you pleaded guilty to. Sure. So that's your conviction. So the question is that face a possible more than a year? So yes, you're right. But he appeared to plead guilty to the Class A felony, so not that it matters either way. So maybe he pleaded down to a Class B felony. It just doesn't matter because even on a Class A, it wouldn't work. All right, so I think I'm going to sign off because, 286 people here. I don't want to sign off. I got a good audience. To ask me anything. 286 people here. I want your likes and I want your love. I will talk about law as long as you have legal questions about stuff. I will try to give you legal answers about stuff. So, as long as it's not personal stuff, because, but as long as it's, stuff that would relate to everybody, I'm happy. Will there be questions? Will there not be questions? I could also just try to grift some more. Please give me money. I like your money. It helps with things. It helps, for example, just upgraded my computer. And a lot of that was from your financial support because I need it at least in part, for the video editing. I mean, that's why I got the new computer. The old computer I had was fine for every other purpose that I use it for, but it wasn't good enough for video editing. So the financial contribution you gave me better video editing, which makes me able to render it faster, which means I can do more, which is nice. Your contributions paid for this camera. Your contributions paid for this microphone. Your contributions help the channel grow. So all you people out there who are supporters, thank you very much. Is Alita's husband military? Yes, he is. Supreme Court react this week on NYSRPA. Is that happening this week? The NYSRPA case? How many cases are happening this week? It's November 3rd. It was today. Shit, dude, man. I don't have time. I don't have time to keep up with all these cases, man. I already got two cases to already do, and now I got this case too. Why are you putting all this stuff right next to each other, Supreme Court? I can't work like this. Given where we are and given my I don't think I can get it till next week. I will get to it eventually. Do I think Kyle will testify? His defense lawyers seem to say that. It seemed to be a thing he said, which seems deeply, deeply questionable to my mind. But okay. What would I prefer to be legalized? I think marijuana should be legalized on a federal level. What beer do I drink? Typically Guinness these days, but you can get me some other stout or porter. That would be fine. Especially since it's getting a little chillier, that would be fine if you want to get me something. My predictions from the 6 charges? Well, I mean, strictly speaking, he's guilty of the misdemeanor violation with respect to the the curfew. I got there eventually. Strictly speaking, he's guilty of that, but the problem is, like, so is everyone else. So if the jury is strictly following the law, he should be found guilty of that misdemeanor. But you have to imagine the defense is going to make the point that, like, literally everyone else there was also violating the thing. And so, it doesn't matter. So yeah, it's hard to predict. Strictly speaking, technically, they should find him guilty. But I think there's a pretty decent chance that he'll get not guilty. I'll probably flow from the other charges, but yeah, that's. For the other ones, though, it seems like not guilty across the board. I continue to be amazed and confused by the reckless endangerment instruction, because you can't have reckless endangerment in the case of a perfect self-defense, as Nate the lawyer was screaming into the void during Nate's chat. You can't have perfect self-defense. But by the way, there's an alternative to perfect self-defense, like imperfect self-defense, which happens. So, like, there might be a situation in which your claim of self-defense isn't as good because of other things that you did or something. So that can happen. So when you say a perfect self-defense, that's the clean one, right? I did absolutely nothing wrong, and the other guy's the complete bad guy. That's the perfect self-defense. The judge asked this hypothetical, and the hypothetical kind of made me very, very confused. So he said, okay, let's imagine, so we're talking about this reckless endangerment charge by firing the gun. He says, okay, let's imagine a scenario where you're on a street and there's a bad guy on the street to which you have a perfect self-defense claim. So we're establishing this. I have a perfect self-defense claim against this bad guy. Fine. But behind him are 4 children. So can you charge the guy with reckless endangerment? And the judge's answer was, I think maybe, because it might be arguable that you could move to a different possession. You can move to a different position to avoid the potential issue of what's behind your target. You could move somewhere safe or seek cover or something. Here's my question to the judge: with what time? Right? If I have a perfect self-defense, it necessarily means there's an ongoing or imminent threat of grievous death or grievous bodily harm, right? This guy is a complete bad actor. I've done nothing wrong. And there's an ongoing or imminent threat of death or grievous bodily harm. That is what I need to have a case of perfect self-defense. Okay, great. You should seek cover. You should seek a different shooting position. With what time? With what time? Also, just basic intent follows the bullet rules 101. I intend to shoot A, but hit B. Intent follows the bullet. If my intent is murder, and I attempt to shoot A and hit B, it's murder. If my intent is to enact lawful self-defense and I shoot at A, but hit B, it's still self-defense. So the judge's hypothetical doesn't make any sense for a number of reasons. You can have reckless methods. Yeah, and then someone's like, well, what if you have a howitzer? And it's like, yeah, I'm not so sure about how the howitzer hypothetical works, but I'm not so sure in this situation. Jay Barr says, Clemson, what year? I did go to Clemson. I graduated in 2004. Go Tigers. Do I have a poll? A poll for what? What am I polling on? I'm trying to go back up in time. Dogbert says tomorrow. Tomorrow I was planning on doing whole women's health. I don't know anything about this bear and what they did or did not do, so I'm not going to comment on that. If you plead true to a charge that has more than 1 year, can you still own a firearm? Well, your options are, I don't know about a plea of true. Is this a Scottish thing? Your options in the United States are guilty, not guilty, or nulla contendere, which means no contest. So if you plead guilty or no contest, that's a conviction. So yes, if you are convicted, yes, it would be disqualifying, regardless of whether you plead guilty or no contest. Cody Sam says, as someone who lives in Oklahoma and seeing all the cases being shuffled from the Supreme Court ruling on this native land, will they ever fix this, or is this life in Oklahoma now? I don't know. I don't know what they will or will not do with respect to the Oklahoma situation. I know they're being asked to revisit it in part. I thought Gorsuch's decision was very solid, despite its pragmatic consequences, but maybe that needs to be taken a look at because of the pragmatic issues. Will I be doing these videos throughout the trial? Probably, at least in part. I can't commit to every day because I have alternative plans, but I'll be trying to do as much as I can. Cause driver gave me MX 200. How much can the IRS take back? How much can the IRS take for back taxes, like wages retirement? I don't know, actually, in terms of how much. Well, it depends. It depends how it's being done. If you are being convicted of, like, if you're being convicted in court, they can just take it all. So potentially all of it, depending on the exact nature of it. But I'm sure there's more specific aspects to that. I don't think the answer is all of it in every possible case, but potentially all of it, depending on the case and depending. Yeah. What law school did I graduate from? I graduated from the University of Akron in Akron, Ohio, and I went full-time. Was Rittenhouse's defense compromised? I didn't see any evidence of that. Just, yeah. Gage's criminal history: DUI, possession of firearm by a felon. Possession of firearm by a felon while intoxicated. In 2015. How was he charged with possession of a firearm by a felon? That's a good question. How was he charged with possession of a firearm by a felon? What is the predicate felony? Hold on. We have to go back again. Hold on. Let's see if we can find out what his predicate felony is, if it exists. Does anyone want to help on trying to figure out if he was charged with possession by a felon? Presumably they thought he was a felon, so how did they come to that conclusion? It is in regard to a juvenile. I don't know how that works for federal law. Let me take another quick look at it. I don't know if federal law distinguishes for juvenile convictions. I don't think it does, but let me just take an air peek. Yeah, who has been convicted in any court of a crime punishable by imprisonment for a term exceeding 1 year. So I would think that would include juvenile court, so I don't think the fact that it's a juvenile conviction changes that. Unless I'm missing something. Yeah. Kyle Rittenhouse was charged as a felon because he opened up someone else's mail. He hasn't been charged with any mail-related crimes. I don't know what you're talking about. Let's see if we can find if Gage was actually... Was he actually charged with possession of a firearm by a felon? Northwest Firearms just says it as a truth. Let's take a look at Snopes. Does Snope want to help me at all? He's been arrested on suspicion of multiple crimes, felony burglary. Okay. If he was charged with conviction by a felon or possession by a felon, I can't find it to know what the predicate felony is supposed to be. Oh, no, I misread this. I'm sorry. All right, I think I might have misreported to you. I'll just say it again. Yeah, the guy we're talking about was arrested on suspicion of multiple crimes, including felony burglary. But yeah, I guess maybe those cases didn't go forward or something. What, it was a joke? Oh, the mail thing was a joke? Pokerman says it was a joke. What was a joke? Hold on. Hold on. Matthew Zizzo asked, when the defense lawyer questioned Kyle's friend, if his lawyer told him he wanted a meeting, he said, no, I didn't know that. What was that? I don't know exactly what that was, to be honest. I don't know necessarily it was unethical for the attorney to not bring that to his client's attention, because that's more of a strategic consideration, but it was a little weird. I almost found what I was looking for. Yeah. Where did my hair go? My hair's fine, man. No. Don't be mean. Oh, I'm sorry. My comment from a while ago was given the two abortion cases, this case, NYSRPA, in your large audience right now, you should do a poll to see what cases are in demand. Okay. Let's do that. So I'll start a poll. Fine. What case should we cover first for oral argument review. And this is what we know as Scottish React. Should we do the the right to bear arms case, NYSRPA, and the Texas abortion cases, SB 8, which is I'll say the two Texas abortion cases. All right, we'll have a poll. Can I not ask a question? What just happened? Okay. Ask. See which ones you guys want first. You got about 2 minutes or something. Your voice matters. Should we do the case that is dealing with right to bear firearms, which is the first major Supreme Court case the Supreme Court's taken up since, McDonald? Or should we discuss the two cases dealing with Texas's SB 8, which is a wonderfully interesting, complex piece of legislation, and the legal stuff is fascinating. But which would you prefer? If anyone can find where this guy was charged with felon in possession in 2015, if they can find that, please tag me on Twitter or tag me on my Discord or something. Bring it to my attention, because I'd love to have more complete facts. So David says, if found legally innocent, do you still think he's morally innocent considering his proclivity for violence with respect to the school fight and the drugstore rant? I'm in no better a position than you to answer moral questions. I have an expertise in law. I'm in no better position than you to answer moral questions, so I tend to not answer them. Because, there's no particular reason for me to. I'm just giving the second. It looks like the right to bear arms case is going to win the day here with 50 votes in, 66 to 34. But I'll just give it a minute more, and then I'll sign off. Matthew Zizo said, I tried posting a link here, but I think it got deleted. Yeah, links are not allowed on YouTube. Can you send it to me on Twitter or on Discord? Or you can send it to me in email. My email address is uncivillawYT@gmail. That's all one word, uncivillawYT@gmail.com. So could you just forward it to me one of those ways so I could take a look at it? Well, I think we've gotten to the end of the poll. It was 3 minutes ago and 52 votes, so I think that's going to end our poll. So with 2/3 of you saying you want the right to bear arms case, all right, so I will attempt to do that first. So I'll try to do that this week. I probably should be able to do it tomorrow. The only limitation would be whether or not OYEZ has a synced up transcript, which makes our lives much easier. So if they have a synced up transcript by tomorrow, we'll do it tomorrow. If not, we'll do it on Thursday. I'm going to head off for now. I hope all is well. Until later, my friends. Cheers and goodbye.